Request the board to approve the following installation and purchase by C&G Video System New York. They were the lowest of the three vendors for $4,116.55, and that's for the security lock system for the three exterior doors at the police department, and that's all covered under the Homeland Security grant, so we'll be reimbursed for the cost.
Motion to approve.
Second.
Mr. Conway?
Yes.
Ms. Tarwacki?
Yes.
Mr. Ryback?
Chief, on this C&G, have you done a background check on them? I mean, they're up against Time Warner and Royal Security.
Yeah, they did all of our video security systems. They do it for the district attorney's office and the county sheriff's office. Yeah, they're well known throughout the county.
Yes.
Mr. Corral?
Yes.
Mr. Kaczynski?
Yes. Mark.
Sorry.
Okay.
Did everybody get a copy of Bob Ventry's letter that was, I think he sent it over early Friday morning, maybe? In a nutshell, what the issue is that the developer was required to post securities for this development for stormwater and swales, but the new stormwater regulations that we have also require them to enter into an agreement with the town that will allow the town to go in and do the work and charge the work that may be necessary back to the developer's taxes for the property. And so what Mr. Ventry has done is, on behalf of his client, the developer, written to you and asked that you'd be willing to just take the security agreement as is, and that you'd be allowed to fix any problems at the premises and attach to their taxes, rather than also requiring the developer to post separate security for that, because he and the developer believe that that's almost like a duplicative thing to have the developer do. And I don't necessarily disagree with that position. If you have any questions about Mr. Ventry's letter in particular, I'd be happy to try and answer them. Tracy, I would suggest that you include it in the minutes, and if you don't have a copy already, I can get one to you. But basically what they're looking for you to do is state that the developer does not need to post additional security for stormwater maintenance and swales in that development. The developer will have to post the security as otherwise recommended by O'Brien and Gear, and I believe they have actually done so.
So the monies we have.
I'm sorry, Charlotte, but you had a question.
Well, it seems to me that this is the opportunity that the town would have to hold money and to secure good work is kind of lost.
Well, not quite, because the main facility we're interested in is the stormwater retention pond, and it's there. It exists. What O'Brien and Gear suggests be done is that additional money be retained in case that facility was not functioning properly within the next few years or so. And the purpose of having that security is so that the town could fix the problem and have itself reimbursed. But because the stormwater maintenance agreement allows us to charge that back to their taxes, why do both? I think is the developer's argument. And frankly, I think it would probably be easier to perhaps attach to their real property taxes than to maybe collect on a letter of credit that they had posted with the town. So it may actually be easier to do that per the agreement than to actually get the money from the securities they posted.
We've done things like this before, Wayne, with properties that were uncapped, unsecured, and all that. You know,
Well, yes, but that's not changing the criteria that we've done for a long time, which is to require the securities up front.
And I don't
leaves the town in a better financial position to
I don't necessarily.
We have more money in our coffers, and to be quite frank, the money's in our coffers is much better. No,
It's not really your money.
Security. All right.
Yeah. And the other thing too is that this stormwater agreement is pursuant to the legislation that you are required to adopt for your MS4 permit. So the idea of not necessarily requiring the developer to post securities and be able to attach to their taxes, that's something you already kind of contemplated when you adopted the legislation.
Plus, the town will be the one that chooses who will do the work on the property, so we will have, in essence, we'd have a little bit more control over.
And I don't want to be seen as an advocate for the developer here either. I don't want to make that clear that this is your decision and you can choose. But because Mr. Ventry wasn't able to be here, I'm doing my best to explain what he put in his letter.
I understand that, you know, we'd be in a better position, we might get it done better the way we want to have it, you know, and then just to roll it back onto his taxes. As long as he's not rolling that on to each of the, well, he's gonna do that anyway, isn't he, to each of the people who buys the property.
I have a further comment to that.
He's gonna do that anyway, so, never mind.
This is a unique situation.
I'm sorry, I'm looking for the town court. It's not this evening, right?
Town court's Tuesdays. Jody,
Are you here for the wedding?
I'm sorry.
We have a wedding arrangement.
There's an arraignment and a wedding. An arraignment and a
go ahead,
wedding.
Charlotte. Charlotte.
Today?
Yeah.
Charlotte, still, who's asking the question? Go ahead.
I'm done.
Okay, where are we?
Who's gonna, the agreement between the town and the developer gonna draft it and then per your review? Or,
It's essentially the standard agreement that your local law requires them to put in place.
Is there a need for us to do something on this tonight, or can we wait for Mr. Ventry to come in and talk to him?
You could, but of course, the developer is looking to have their map
It's
finalized.
a big decision anyway. You know, I don't think he's gonna be able to enlighten it any more than what Heather did, it doesn't seem to me.
Yeah, I just want to point out, this is a somewhat unique situation for, I think, two reasons. One, this is one of the first agreements that we've executed for the stormwater facilities. And number two, that they have a property owners association in place, which is not typical for most projects. The usual process relative to securities, I think, is still going to be applicable for a majority of the situations, but this is a unique situation.
I concur, thank you.
I would go forward then and make a motion that we not require the securities for the stormwater project for Carmel Run Section 3. However, we will require them to enter into the typical agreement for the attorney's review.
To the form of motion?
In the form of motion.
Second.
Mr. Conway.
Yes.
Ms. Tarwacki.
Yes.
Mr. Ryback.
Yes.
Mr. Coro.
Yes.
Mr. Kaczynski.
Yes. Jody?
Yes, I'd like to ask the board for a resolution for the approval for Chet to sign the DSS contract for funding for the teen center for 2009. It's the same contract we've had the last 4 years. I'll let Heather review it if she'd like. Pretty standard contract that we've had.
Motion to approve.
Second.
Mr. Conway.
Yes.
Ms. Tarwacki.
Yes.
Mr. Ryback.
Yes.
Mr. Coro.
Yes.
Mr. Kaczynski.
Yes.
Did you want to do executive session now or after public input? It's up to you. I was just
Let's do public input,
Oh.
just in case. I'm not sure we're getting Raymond coming in the wedding, so.